Victim impact evidence, one of the more controversial areas of capital punishment. At the penalty phase of a capital trial, the prosecution can, in most states, put on evidence from the victim's family or members of the community to talk about what the impact on the community has been and on the survivors. The Supreme Court first said in Booth versus Maryland that this evidence was not admissible, but just a short time later, after a change in some members of the court held in Payne versus Tennessee, that such evidence was admissible, and now in almost all the states that have the death penalty, victim impact evidence is admissible. I've asked 5 students from Yale Law School to come here and discuss the various aspects of victim impact evidence with us today. I want to introduce Megan Wachspress, who is from Chicago, who's with us, as well as Emma Kaufman from Carlisle, Pennsylvania. To my immediate right is Jamil Giovanni from Toronto. To my left is Jamelia Morgan from Los Angeles, and finally Virginia McClimate, who is from Iowa. So I want to thank all of them for joining us here today to talk about this subject. And Jamelia, let me just start with you. What is a victim impact evidence? What does the jury do with it?
Well, the jury is going to use that information to sort of get the full picture of the harm caused by the crime, in particular the impact on the family, whether it's financial, emotional, psychological, trying to get a larger picture of what happened as a result of the crime committed by the defendant.
And Emma, what does the jury do with that? I mean, how does it weigh it? It's deciding, it's got aggravating circumstances, mitigating circumstances. What does it do with it?
I mean, I think theoretically it goes to the jury's understanding of the victim who was lost and the extent of the harm committed. So it gives the jury a better sense of who it was that was affected by the crime, which goes to the gravity of the crime.
Megan, do you have any different?
Well, I think it also serves a purpose within the courtroom for the victims themselves. I mean, it's introduced after or alongside the mitigating evidence stage, in which you get a much fuller picture of the defendant's life and why they're deserving of the jury's sympathy. And so it feels like a way of counteracting that vision of the defendant in defense of the perceived harm by the victim and the victim's family.
Ginny, is that part of why this evidence is admissible, to balance out the mitigating evidence about the defendant with this evidence about the person whose life was taken?
I mean, I think that's theoretically one of the rationales for it, again, to get a full picture of the crime. I think a lot of people would say that that is prejudicial, that in the penalty phase you're looking at the defendant and it's about that person and their life, and so extra information about the victim just serves to confuse what's happening in the courtroom.
Elaborate on that just a little bit. Are you saying maybe this evidence should be admitted, or it should be, one of the questions we have, of course, is not only if it's going to be admitted, which the Supreme Court has pretty much decided, but the scope of the evidence once it comes in. How much evidence is going to be allowed?
Right. Yeah. I think you have to be very careful about how the evidence is presented, and so because it can have extraordinarily prejudicial effects for the defendant, and I think that. Often, I mean, when you're looking at a capital case, you're always going to be dealing with someone who's died. Like, there's always going to be someone who's dead, and so that's obviously hugely harmful for the community. But when you bring in all of these people who are talking about their loss, there's a risk that the defendant isn't going to get a fair trial.
Jamil, what are your thoughts about this in terms of, is a fair trial risked by this? Could this evidence be too emotional, or what's your take on it?
Yeah, absolutely. I think there's a risk at hand here when you have people kind of pulling at the heartstrings of a jury. They might make decisions that are more motivated by emotional appeal as opposed to fairness, or as opposed to what is the kind of reasonable application of the law. But ultimately, I think there's the important thing is the restorative aspect that I think it can give to victims, and making sure they get to play a part in the trial, and making sure that their experience through the crime is being weighed by people, and that there's some fairness to their process and some closure for them as well.
Before we go into scope, I mean, is there anybody that thinks this evidence just shouldn't be admitted, that the court got it wrong in Payne versus Tennessee? Emma?
Yeah, I think Justice Stevens wrote in his dissent to the opinion that allowed it in that we're just entering uncharted seas of irrelevance. I think that was how he put it. My impression is that what you're supposed to be thinking about during the penalty phase of a capital trial is the defendant's crime and whether or not the defendant's life has mitigating aspects to the sentence, right? So I just think we're going beyond the scope entirely of what is at issue in the penalty phase.
Megan?
Well, I think that there's a real risk that it sets the jury up to believe that the only way to do proper or to properly honor the life of the victim and to show respect for the victim is to give the death penalty. When those two, whether or not to choose death for the defendant and whether or not one honors and appreciates the loss of the victim seem to be two different determinations that get conflated or confused by the admission of victim impact statements and evidence.
Let's spend just a moment on talking about the scope of this evidence. Some courts have allowed just very brief statements being made by witnesses about the person who's no longer in life, the victim of the crime. Others have allowed it very elaborate, even characterizations of the crime, the family talking about what punishment they want imposed. In the materials we cite to Justice Stevens' dissenting opinion in one case in which he put a videotape on the website with regard to a 20-minute videotape about a person. Is there any limit? Is there any limit to this evidence?
Well, I think that's part of the problem that was wrong with sort of the Payne decision in general. The court didn't really set any standards or guidance for courts to apply in deciding what should be the scope of this evidence. And so now you have cases where there's videotapes, maybe 40 minutes long, an extremely long composition by Enya or something along those lines, where the evidence is extremely emotionally evocative. And so there's really an issue, I would say, with scope. And the courts haven't really, across the board, found a sufficient way of sort of challenging this type of evidence and ensuring that there's not disparities between courtrooms and defendants given the quality of the victim impacts, that evidence that's presented.
And certainly, Jenny, we see states have taken different approaches. I mean, some states like Oklahoma has allowed all sorts of evidence to come in, whereas Georgia requires a hearing before where the witnesses testify and only very limited presentation.
Right, and I think that again gets to the problem with the death penalty being arbitrary and capricious as administered in different states, that if you are going to allow this kind of evidence in, I think it has to be pretty severely constrained in terms of what you can offer. And I think it's just really difficult because, as Megan said, it's something for the victim and their family to be able to express the grief at the loss, and but that's really not, and that's something that needs to happen. It's just not clear to me that where that needs to happen is at the penalty phase of a capital trial, when the issue is really the individual defendant and their individual sentence, and they're being prosecuted by the state for what they did that was contrary to the laws of the state. And so it's hard because I think you have to draw a pretty fine distinction between what the purpose of the penalty phase is, and even though part of it is honoring the loss of the victim and their family, that's really not the main purpose.
Of course, too, the quality of this evidence is going to vary some depending upon how articulate the members of the victim's family are. You may have people from a prominent family. You may have someone who has no family at all, so there's no one to testify. Justice Benham of the Georgia Supreme Court expressed some concern about two classes of victims. Are we concerned about that, Jamil?
Well, I think we're concerned about that insofar as there are, inequalities and disparities in American society, and so you're going to have different levels of education, different degrees in which people can be eloquent and articulate their experience through a crime and the impact it's left on them and their families. I don't think that a trial is where we necessarily need to be concerned about trying to equalize this. We're essentially asking ourselves, are we going to make a qualitative decision about how well we think someone communicates or articulates? And I don't think that's really the goal here. The goal is to create an opportunity for people who have been affected to speak about how they've been affected. I think there's a great point, I believe, made by Justice Scalia, where he talks about how there's going to be differences between one defense attorney and another. There's going to be differences between one prosecutor and another. There's always going to be these qualitative differences in how well someone can be articulate and how well they can be an advocate. And I think that that's a natural part of the legal system. And I don't think being too preoccupied with that is really the point here, that every victim is going to come from a different angle with different things to say, and we need to respect and honor that can come in different forms.
So you're saying this is just the vagaries of the system. In any crime, it may be that the witnesses are articulate or not, the witnesses to testify. The lawyers may be of different quality.
Absolutely.
And so forth.
And if we're uncomfortable with those kinds of inequalities, then I think that's a conversation we need to be having about our schools and our larger social issues, and not when it comes to a trial.
Emma?
I mean, I agree with Jamil that we need to be having a broader conversation about embedded inequalities. But it seems to me that if the goal in sentencing is to determine what's appropriate for the crime that was done, that there's something wrong with a hierarchy of victimhood in which those people who know more people, who are more eloquent, who are more well-connected, are going to have more of an emotional impact on a jury than those people who aren't, right? Ultimately, the impression you're giving is that murdering someone who's more prominent in society is more problematic or more offensive than murdering someone who doesn't have family members to come testify on their behalf.
Anyone else want to comment on that, Megan?
Well, I think that there's some worrisome intersections with, for example, the results in McCluskey v. Kemp of the empirical study of when the death penalty is granted. And so you already
Well, now in that
see-
case, you're talking about, just so everybody knows,
Oh,
you're
yeah.
talking about the case racial discrimination and the racial disparities in the death sentence.
Right, so yeah.
Yes.
So through very extensive empirical work, they found that the way to increase the likelihood of receiving the death penalty is basically to be an African-American individual who murders a white individual. And the way in which the kinds of effects of what lives are considered valuable and what lives are considered, the death of which people is considered a particularly heinous crime, I think, given the broader structural problems our society has, intersect with in really uncomfortable ways with a phase of the trial devoted to measuring the severity of that impact.
Well, back to my earlier question about the scope of this. What should the scope be? I mean, should we allow, extensive testimony with these videotapes and so forth, or is there a principled way to decide how much evidence to allow?
I think that's a very difficult question. I don't think that there have been many courts that have really addressed that head on. But I do think that I agree somewhat with the per se bar as relates to victim impact videos. I think it's very hard to sort of standardize the quality of victim videos as technology advances, as there's differences in resources. And I also think that the approach adopted by the Georgia Supreme Court, I believe, to go through written testimonies and allow victims to present their testimony through a written statement, but then go through and excise those parts that are maybe very prejudicial towards the defendant, referring to the defendant, let's say, in a disparaging way. Keeping the focus on impact might be one way of channeling the evidence that's presented to the court and trying to keep away testimony that might unduly inflame the jury. So I do believe that statements should play a role, but victim impact videos, I don't think that there's a principled way of channeling those types of videos, perhaps outside of maybe a hard time limit, but then you still couldn't really control the quality. So I would say that's probably one approach.
Of course, and in California, those videos are quite often admitted and are pretty much standard practice in that state. The Supreme Court really hasn't looked at this since the time of Payne, in which at least Justice O'Connor said this was a brief glimpse at the victim's life. But at least we see in some states now it's a much more elaborate glimpse than just a brief glimpse. Jenny?
Yeah, I really agree with what Jamelia said, that it's, I think to the extent that you're going to allow it, it has to be fairly circumscribed and controlled. And I think the court should know in advance what's going to be said, and essentially the only way to do that is through a written statement. I think that, again, these victims and their families have had hugely traumatic experiences, and it's if you got into a situation where someone said something that was, the court eventually said was more prejudicial than probative or whatever, it's very hard for, it's very easy for just one comment to taint the whole trial or the whole penalty phase. And so definitely I think the videos are really problematic, especially with, the soft music in the background, and it's really, these are very moving things, and they should be. It's just, I don't think that they belong in the courtroom.
In one of the cases that's in the materials, George Battle's case, the prison guards, this was a fellow who was accused and convicted of killing a prison guard at the penitentiary in Atlanta. And guards testified at the penalty phase that it would be bad for morale if Battle was not given the death penalty, good for morale if he was given the death penalty. Should that type of evidence be admitted, Megan?
Well, that gets a little bit trickier because there are already provisions within our criminal laws that make the severity of punishment associated with killing a public officer, such as a policeman, the penalty is higher than to kill an ordinary citizen, in part because the criminal justice system is meant to be the action of the state against the individual and the collective against the individual rather than just the victim against the defendant. And so for me, the trickiness in that case is because they're making an appeal to the broader social or institutional effects of the crime, and they're basically saying this impedes our ability to carry out a public service in the same way that the death of a police officer impedes the ability of police officers to carry out a public service. And so while I would find I'm uncomfortable with the admission of that testimony, I think it does push up against this larger contrast between who exactly is pursuing the defendant in the trial and whose justice are we seeking, the victims or the states, in a way that perhaps the more personalized victim impact statements don't. They don't push up against the public function of the trial in the same way.
The fact that the victim was a police officer or was a guard at a prison is often an aggravating circumstance. So that's already in the mix there.
Yeah.
But then the question becomes, can members of the police department, members of the guards group at the prison, can they say, this will affect our morale or you will show your support for the police if you give the death penalty in this particular case? Emma?
I mean, I would think not, right? I would think that was extremely prejudicial. And the question that raises for me, if we're going to admit it, is why then it wouldn't mean that we're also admitting testimony from the family members of the person who's going to be executed about the potential effects of the execution on the family, because that's another class of prospective victims here that we don't talk about very much. And that kind of testimony doesn't come in very much. But there are cases in which people say, you know, you're going to execute my father, that will have long-term effects on me. So should we be letting that in if we're going to be letting in police officers saying this will prospectively affect my morale in a certain way?
What does the defense lawyer do? What let's say hypothetically, what if they're negative characteristics of let's say the person who was the victim in the crime was actually somebody who may have been involved in illegal activities or may have done other things that would not reflect favorably on them. Is that going to be introduced as part of this evidence? Jenny?
So I think that's one of the reasons that I find victim impact evidence so problematic, is because the 14th Amendment guarantees a right to due process, and a big portion of what our country believes that due process is adversarial testing. And there's just no way that you can really attack the credibility of a victim in this case, because the person has died. They've been the victim of a horrible crime. And so I don't think that if I were a defense lawyer, I would feel that it was extraordinarily risky to try and attack that kind of evidence. I think very quickly you're going to look petty, or like you're playing games, or like you're not respecting the fact that this is a horrible loss. And it is a horrible loss, and that should be respected. And so I don't think there's any way to effectively cross-examine the testimony. I don't think it can be subjected to the kind of adversarial testing that we think is essential to due process.
So if you're the defense lawyer, you're probably, even if you know that, not going to put that evidence on. Right, Emma? Is that
Yeah, that seems like an impossible choice. I would think you would always choose no.
right? So that was one of the concerns Justice Powell had, of course, in the Booth case, was that there really may not be much back and forth with regard to this kind of evidence. Well, any final thoughts that anyone wants to share?
Yeah, going back to the previous question, we're talking about crimes happening in a social context, and I often think about the case being brought against George Zimmerman about the death of Trayvon Martin, and think about the importance of victim impact evidence being brought into that trial as it goes on, and the need to make sure that the voices of people who have been affected by the death of this young man are going to be heard. And I think that that's an example that I think challenges some of our assumptions about who is a defendant and who is a victim. And in this situation, I think that there is a lot of justice that can be given to communities, young people, black communities that have been denied justice for long periods of time, by letting their voice and their experience be part of this trial. And I think that's an example where I think we're going to see, if we see victim impact evidence brought into that trial, I think we can see a lot of people who have been denied justice in the past feel like the criminal justice system in America is starting to do them a favor, or work in their favor, I should say. And I look forward to seeing the conversations around that.
Of course, that's a very high-profile case. What about the day-to-day case?
Yeah, I
The
mean,
cases that we don't hear about on the national news, and they're just what's going on in communities all across the country.
yes, I think that victim impact evidence introduces or perhaps exacerbates some structural disparities that we already have existing within our criminal justice system around access to counsel and competent counsel. Perhaps counsel knows that the victim impact evidence will be prejudicial but doesn't raise that objection in the trial. And so now we have individuals sentenced to death because of the quality of victim impact evidence. And that, I think, is an impermissible risk. And that's something that we worry about when we are imposing the death penalty to the extent that the society continues to do so. And so although I agree with Jamil on incorporating the views and perspectives of the community and ensuring their voice, the voice of the victims in this process, I think we have to be very concerned about how we are embedding within to the process more structural disparities that we as a society have not decided to rectify.
Ginny, would you add anything to that?
I would just add, I agree with Jamil. I think his point is well taken, but I think that we need to be really careful and remember that in individual trials, we still have an individual system of adjudication. Ultimately, it's about the individual who committed the crime allegedly and you know what happened around that. So I think that cultural context is important, but I think that we can't allow that to get in the way of the individual defendant having a fair trial. And there might be other contexts where it's more appropriate to have those conversations, which are essential, but maybe not at the penalty phase of a capital trial.
Chris, most people on death row are there for crimes against white people, overwhelmingly, even in states that have large African American populations. Georgia, for example, 80% of the people on death row are there for murders of white people. Is that a factor, Emma?
Yeah, I mean, I think the things we're getting at here today, in Jamil's comments and in these facts about race, are that these are much broader structural issues, right? And there's a desire, I think, in what you're talking about, for a more restorative model of dealing with a crime and for a more restorative model of dealing with the history of racism in the United States, right? We want to have a bigger conversation about where this country is, and it gets condensed into the penalty phase of a capital murder trial, which feels like an odd place to do justice to the past or to racial injustice. But yeah, I think if you start to look at the numbers, you start to look at jury composition and people of color being excluded from juries, you start to look at the McCleskey study and the number of people who are being convicted solely because the aggravating factor is that they are African American, you start to just have fundamental questions about whether we're really talking about a justice system.
And if this larger conversation isn't going on or doesn't come to some resolution, which seems like it's been going on for centuries, what do we do in the individual case, Megan?
Oh, wow. I think that we very much need a space or some kind of social recognition of the harm associated with murder. That a lot of what Virginia's been saying about the deep need for victims' families to gain public appreciation for their suffering. But it doesn't fit into the adversarial trial. It's not fair to any individual defendant to compress all of those wide variety of issues into the penalty phase. And so in the meantime, I suppose my preferred solution is to exclude most of this evidence, absent maybe some written statements, but also to work on developing forms of restorative justice or alternative procedures that don't determine whether a person lives or dies, but nevertheless provide this opportunity for social recognition of the harm, the very profound harm that has happened in any death penalty case.
Well, as this discussion is brought out, this is an incredibly contentious issue. And there are questions about, well, should it come in at all? What's the limit? We've just touched on some of those things. We could talk about them a lot longer. But this is how long we'll talk about them today. I want to thank everyone for coming and being a part of this discussion. And I hope that it's helpful as we think through this question, because eventually the Supreme Court probably will look at this question again and decide some of these things we've talked about, particularly about the scope, by that I mean what evidence is going to be admitted, how extensive it can be, characterizations, the sort of opinions like in the Battle case that we discussed. So thank you all very much. We're most grateful to you for your contributions to our discussion.